Good evening, everyone, and welcome to another episode of Startup Series. I promise that by the end of this session, you will know how DPDP Act is going to affect you as a founder or as a consumer, and what practical implication and the next steps. For those who for whom this is the first time on this startup series, I am Govind Kedia and I run Arctic Invent, which help companies increase their enterprise value by way of building business-centric IPR portfolios. My company, Arctic Invent, has worked with over 1,000 plus startups from Europe, US, and India, helping them build a massive value on their product and technologies. India's digital adaptation has been nothing short of transformative. Today, you're ordering dinner, hailing cab, or even booking your next vacation, doing everything you need, all with a few taps on your smartphone. But here's the thing, each tap is a breadcrumb in a trail of digital data you are leaving behind. It's like we are living in a digital fishbowl. Every time your corporate ID is being set up, every prescription you fill, every cappuccino you paid for, with your smartwatch, it's all data. And not just any data, but personal, sensitive. This is who I am kind of data. The sheer scale and diversity of this information collection is dizzying. Unknown to most of us, these convenient apps collect more than just your order history. They're gathering snippets of your personal life. So the question begs, where does all this data go? What is being used for? Who is making sure it stays confidential? And as everybody says, that data is a new oil, right? On August 11, 2023, India passed the Protection Act 2023 (DPDP) Act, a game-changing piece of legislation, so to say, that's stepping up the guardian of your digital identity. A living, breathing framework that touches us all. Act impacts every digital footprint we make. And this is our subject of this episode in the startup series. Whether you are a startup maven, an aspiring entrepreneur, an established businessman, or just someone who cares deeply about their digital footprint, this episode will break down how ACT is going to change things for you, for your business, once it's implemented completely. Our guest speakers are authorities in the data protection who will offer insights from both from legal and tech world. Now, first guest, Nakul is, of course, our first guest is Nakul. Nakul is partner at DSK Legal with a rich background in business and tech law. He played a key role in many big deals, both in India and globally. Nakul has sharp eye for details and he always makes sure that data privacy is top priority. He is also well versed in new technology trends like blockchain, virtual reality, online gaming. His advice covers many areas from online shopping to healthcare to IT. This makes him great at giving the right legal advice for different businesses. Some of you might know him from his chat on Storyboard 18, where he talked about the of this act of 2023. And Nakul and I, interestingly, share same alma mater and graduated from the engineering college almost at the same time. So it's very special for me to host him. Let's give a warm welcome to Nakul. Welcome to the startup series, Nakul. Would like to add something to your introduction? It would be great. And thank you for joining us.
Hey, thanks, Govind. Thanks for your you know enlightening words about me. But as you rightly said, I am a software engineer turned lawyer. Have been practicing corporate law for the last 11 and a half years. Always been with law firms, and my primary consultancy area has always been general corporate, private equity, mergers and acquisitions, with a special focus on technology, because I come from a technology background, being a computer science engineer, and used to be a software developer at one point in time with Infosys, uh, and therefore the love for technology. Uh, I'm a partner at a firm called DSK Legal. We are 300 strong lawyers in India with offices in five cities: Delhi, Bombay, Pune, Bangalore. We are a full service law firm, and advise Indian and international clientele on almost everything in terms of the Indian law. Uh, that's some brief background about me. Would
Sure.
love to talk about the Data Protection Act to the community here.
Great. Thanks. Thanks, Nakul, for accepting the invite. My next guest is Keshav. He is Global Data Protection Officer at VWO and wears many hats. And VWO, interestingly, works with a lot of companies including Amazons of the world and Googles of the world. And he is a computer engineer, a cyber lawyer, and a strong voice stating that privacy is a myth. His credentials are impressive, being certified privacy professional, privacy manager, and holding key ISO certification. In his day to day, Keshav is deeply involved in making sure personal information is safe, conducting privacy checks, and making sure companies follow worldwide privacy rules. And before VWO, he worked with big names in India focusing on cybersecurity and data privacy. He trained thousands from students to professional on data protection. But his reach doesn't stop here. He trained over 20,000 police officers and law officers in India about cyber crimes. He has even helped several police departments to solve cyber cases for free. Keshav has won big in ethical hacking contests in top places like IIT Mumbai. Let's all welcome Keshav. Welcome to the Star Series, Keshav. Let me know if I missed something. I know it's a very short, but please add if I missed something very critical here.
Thank you so much, Govind, for inviting me here and providing me the opportunity to discuss on the new data protection law with the group in the community. And you have covered, I guess, everything. And thank you so much for the warm introduction. And yes, that's it about me. You have covered everything. I'm a engineer, same like Nakul, and then a converted lawyer. I used to be in the world of ethical hacking, red teaming, and other things, and then a turned data privacy professional. Currently working
Sure.
with VWO. That's it about
Great.
me.
Great. Well, thanks. And very interestingly, all three of us are engineers talking about law, of course, have some understanding of law. So, audience, don't worry, we understand law. So, while we are engineers, but we understand law. So, you're in safe hands for sure. So, Keshav, I think let's kick off the episode with you. And you have said, and I quote, privacy is a myth. Can you elaborate on that? And also, in view of this new act, do you still feel so? If yes, then why so?
Okay. So you already answered your question in the pre-context of this complete call. You mentioned, I heard you mentioned, unknown to most of us, these convenient applications collect more than just your order history. They're gathering snippets of your personal data. And that's how things are happening in today's world. You are getting 95% of the things just free of cost. Every social media is free of cost. Every communication application is free of cost. How? It's not free of cost. It's on the cost of your personal data. And that's a reality. Data trading, data mining, these are now the biggest businesses anyone can think of. So this is a one factor. The second factor, that's more of a psychological factor, and my philosophical factor. Whenever I talk about privacy, I talk about that factor, is a human nature, the nature of our Homo sapiens. If I am recalling, in last 3 months, the biggest reality show in India was like Big Boss. The most viewership of any reality show till date is with Big Boss. Okay, so what's Big Boss is? It's people love to see invading privacy of 15, 16 contestants every day for continuous 60 days, calling it as seeing user behavior. That's what Big Boss is. People are loving invading privacy of 15, 16 individuals for non-stop 60 days, 24 into 7. Because that's what human psychology is. Everyone is interested in others' life. What's your salary package? How much you're earning? Okay, who is your girlfriend? Where are you going? In which hotel you stayed? That's a general talk I can see everywhere because that's a psychological thing. Privacy is just a myth. That's why I say. And also coming to real world, the technological world, you are installing an application in your mobile phone. That application is having access to your call logs, your microphone, your camera, your gallery, everything. I'll
Mhm.
not name any brand or any application. So the most common application which everyone will be using here for any payments or any booking flights, hotel bookings, just go to that application settings and then see location permissions. You'll be surprised to see that payment
Mhm.
application would like to access your camera. Okay, then your photographs, then your microphone, then everything is in your phone. It's a real time location. That,
Hmm.
why? And what is all this? So that's there is a the long story why I always say that privacy is a myth as of today. And I assume that this new law will bring a change to the society. Definitely, it's a very good start. And in the upcoming days, I'll say no, I was wrong. Privacy is not no longer a myth. That's
Thanks, Keshav. And I suppose that possibly gives us an argument as to why this act was necessary. Nakul, can you add to that and tell us why it is an important piece of legislation from from privacy point of view? What's your view on that?
So see, if you if you look at the act, this dates back to 2017, when privacy as a particular right of an individual was declared a fundamental right, in the case of Justice Puttaswamy versus Union of India. uh, if you if you understand the logic of law in terms of the constitutional mandate under it, under which under Article 21, where right to privacy was considered as an impediment, was considered as one of the factors which drew its constitutionality from right to life. uh, while it was declared as a fundamental right, but there was no arms and limbs to such kind of a right unless the law comes into picture around that fundamental right. People and the citizens of India, or for that matter, as we call it, data principles, would not draw their right legislatively from from the statutes in India. And therefore, you know after many iterations from 2017 till 2023, there were certain bills in 2018 and then in 22, and after which we finally now have a Data Protection Act in 2016, 6 years down the line, when privacy to human life was declared as a fundamental right under the Constitution of India. So this has been the overall background. I mean, for this right to come into a legislative act which sets out the particular rights that a data principal, for that matter an individual, will have against the data fiduciaries who will collect the data for all these processing, uh, which were highlighted just as of now, in terms of whether privacy is a myth or not.
Sure. No, great. I think it's very, very important, and that's where we started. And now, what we would like to do, in the next rest of the time, is basically try to deconstruct this entire, act in a very simple layman, on a lot of terms being thrown around to founders and startup folks, and also people who are running the business, and suddenly they are like, what's this, right? So I think that's where we will try to get at during the conversation. So the first question is that, okay, let's define, what is the digital personal data? I mean, what's the ambit of it, right? And before I let you answer, I do want to remind people that a lot of live guests are here. So would like to remind you to put your questions down in the comment section. We have first question by Adi. I'm sure we'll pick it up later part of the conversation. But please do put your questions so that I can pick up as in when we find a context and we find a conversation, right? So let's have this understanding that, okay, what is digital personal data, right? So Keshav, maybe you want to pick it up first, and then Nakul, can you define from the law perspective? Yeah.
sure, definitely. I'm hearing a disturbance.
Um, yeah, there's some disturbance. Can we? Can you, Nakul? Can you mute yourself for a minute? Probably it is yours, or let's restart. Oops. Okay, it's probably Nakul's mic. So Nakul, yeah. Keshav, please go ahead.
Sure. You asked about the digital personal data.
Yeah.
Section 2N of the Act defines the digital personal data in just, I guess, 4 words. Any data, any personal data in digital form is digital personal data. Now,
Hmm.
what exactly is any data in digital personal form is? One, any data which has been collected digitally is
Hmm.
digital personal data. Second, any data which has been collected in form of hard copy but then digitalized is digital personal data. Third, any data which, uh, or the vice versa, any data which has been collected in form of physical forms or anything and then digitalized is digital personal data. Any data which has been collected online is digital personal data. So these are the two major things which digital personal data means.
Sure. So, Nakul, would you say personal data in terms of law, is it simply name, phone number? Uh, what are the, like, can you name some from the law perspective? What do you call as digital data? I mean, personal data. What's a personal data to be defined as?
Okay. So until this act came into picture, the original piece of legislation which we had to govern with the privacy laws was the SPDI rules of 2011, which finds its genesis under the Information and Technology Act of 2000. If you see, the data there was divided into two parts. I mean, there was a larger set which was called personal information, and then there was a subset of that data called sensitive data and information about an individual. Now there were, while personal data was broadly worded in terms of any data about an individual who is identifiable by or in relation to such data, the SPDI there was, which was a special subset which demanded a higher scrutiny in terms of obligations on a data fiduciary, not defined there. But those were the examples given in as part of the SPDI, which was passwords, financial information, biometric data. If you look at the current construct of the act, you don't have this distinction between what is an SPDI or what is a personal data. There is this larger level data set which is called a personal data, and this may be your name, address, phone number, age, even biometric information, financial data, credit card information, and also such kind of data which you can combine with each other and identify. So for example, if you say that I sit out of the Delhi office of DSK Legal, and there is one engineer who is a lawyer, which uh, identifies me as one of the person, this is also a personal data. It need not specifically be targeted data which individually highlights me. This data can be in combination of the others. So this is what personal data seems to be in terms of this act.
Okay, so it means that even the indirect data will be kind of part of the data. I mean,
So long as you can connect those dots and come to a conclusion that this is what the person we are talking about.
okay, cool, great. So that's very very insightful. I think we should know that. Okay, now the digital, what does it basically covers as a whole? Now, broadly speaking, the act identifies three players. Data principal, data fiduciary, and data processor. What are the definition of each in the act, and what role do they play, and what are their responsibilities? Let's start with the data principle for that matter, right? So either okay, so Keshav, if you want to start off, give us very layman term what data principle is and what really means.
Okay, so data principles in a very layman term are human beings whose data are getting processed, or living individuals whose data are getting processed. In GDPR terms, we call it as data subjects. In this DPDP terms, we call it as data principles. You, me, anyone, any living individual whose data is getting processed is a data principle. And there are two important points to note here is for any child, the data principle is the parent or the guardian. For any person with disability, the data principal or the person who cannot is not of a sound mind or is with any disability, the data principal will be the guardian of that particular living individual. So data processors, or you talk about data fiduciaries, those can be a legal person or a natural person or corporates and enterprises. But this term data principal needs to be a living human being, and that too a data principle of India. That means any living human being whose data is getting processed in India or outside India will come under the ambit of this act and the definition of data principle.
Okay, great. So I think very very interesting. I want to pick from where you left in terms of the nationality of the principle. So maybe Nakul, can you build a bit on? I think it's very clear what is data principle, but can you build on this? What does it mean? It has to be Indian anywhere, or I mean, how does this scope defined? Only in India? What's Can you define a bit more?
No. So the act is not restricted to the territories of India. This is the provisions of the act uh, streams down to having cross-border international jurisdiction also, and therefore we can't create that distinction that this particular subject or this particular identifiable character in the Data Protection Act is in not Indian, and therefore the act does not apply. Uh, the the measurement or the yardstick to actually check whether this act applies or not should be in what capacity are you dealing with that individual or an entity. I mean, if it's a data fiduciary, which is a person who himself or through someone else's collects personal information, personal data of an individual, the act applies. The data processor, by way of its definition, means that any person who processes personal data on behalf of the data fiduciary. So there is a distinction between data fiduciary and data processor, because we'll talk about it in a little more detail in the course of our discussion today. But the primary differentiation between data fiduciary and data processor is that while this act prima facie in terms of its obligation applies to data fiduciary, the data processor has been kept out of it. I mean, there are no active obligations on the data processor, unlike which you find in GDPR. uh,
Hmm.
and then comes the data principle. I mean, the data principle is as Keshav also suggested, in case of a child, it also includes a parent, uh, a guardian, in terms of a person with disability, and that disability is not defined. So I would mean to assume it to be a person with a mental disability or a physical disability, but that would also assume their lawful guardians as to be their data principles. Uh, and these are I believe the important definitions in terms of act to classify yourself in terms of hitting these obligations on you. And lastly, there is this definition of processing which is important. What is called processing? While the act specifically provides that the processing is of the wholly or partly automated the data. uh, for example, I mean, if you maintain a register in a physical form, and you put in information of an individual, his name, date, address, date of birth, that the ambit of the Data Protection Act does not cover that unless it is digitalized, which is not true in case of GDPR. I mean, GDPR extends to non-automative use of the individual's data. I mean, it extends to the offline data also, but we have restricted this act has to its larger extent. If you look at the name of it, it's called Digital Data Protection Act. It has restricted its uh, nuances to the digital part of the data that we are mostly dealing it with.
Sure. So again, you picked up to simplify this conversation. Can I say, like drawing a simple metaphor for the audience, is that let's imagine there is a register, like a visitor register in our office, right? And the person who we are entering are basically data principals, right? Anybody whose name get noted is data principal, right? In that register, that register belongs to a company which becomes a fiduciary, which means that is like first party who is basically owns that data in that. Okay, that is the reason that person has come and say noted their name there. And the processor means that if that company gives that register to somebody to say that, hey, give me some insights to it, will that be a very fair way to simply understand this three parties? Keshav, your take, or you want to make it simple for listeners here?
Okay. So you mentioned about the register. The moment a register, the entries in the register gets digitalized, or you're making a directory in your computer machine, that moment that data becomes digital data, and this new DPDP is applicable on that particular set of data. The moment it gets digitalized, and
Sure.
the company or the organization or the enterprise or a living human being who is now, there is a very important point to note that data fiduciary can be an individual living human being also. A data fiduciary can be enterprise, a data fiduciary can be a company, a data fiduciary can be a firm, proprietorship, partnership, individual, sole ownership, anyone can be a data fiduciary. The moment that data fiduciary input that data into the computer system, that particular company is the data fiduciary. Now they need to share that particular set of data to a third party or a third company, maybe for analysis, that how many men entered my company in last 30 days, how many women came to my company in last 30 days, for any purpose. That third party will become a data processor. Now this data processor can process information only for the purposes and only for the duration and only as per the instructions and only for that particular purpose given by and provided by this data fiduciary. And the terms I mentioned, purpose, duration, and means, these everything needs to be documented in form of an agreement or a contract. And it
No,
is a
sure.
legal.
I got it. No, I think the reason I asked to make it simplify is that now it is very, now in a very simple term, whosoever is listening, that data fiduciary is basically the startup or company we are putting in the middle, right? Who is going to be responsible for this protection as well? I mean, that's where I was trying to arrive at, that okay, there are three parties or three key players in this entire act, and the data fiduciary is what, let's say, if a startup or a company is dealing with personal data of customers or employees and so on and so forth, so they become the data fiduciary. So I think that is where I wanted to get everybody to understand that the data fiduciary is a very very important kind of conversation in terms of understanding that okay, they are in the spot now, right? I think Nakul did touch upon that there is no mention of processor and what's their liability, and you also mentioned that. So I think that's, if I understand it correctly, to make it simplify. I know I'm trying to oversimplify things, but simply wanted to do that ways to be making very very simple for people who are listening for the first time about these topics, right? So I hope I'm correct and going in the right direction.
Definitely.
Cool. All right. So I think that's very clear now. So data processor is also clear in that ways, right? So we all collect data in some form or other, right? As business, it could be contact details of people who we employ or vendors we work with, the visitor of our website looking to download a document or sign up for a webinar, or most commonly data of users or of our product and services. Are there any guidelines as to how this data can be collected or procedures we have to follow them now, especially with this new act? What are some of the basic things that you would at least want to cover on the act side of it?
Okay, sure. So there are two important aspects when we talk about the data collection part. Because when we talk about processing, the very first stage in processing is collection, and it ends with destruction. So anything and any operation on a data, like collection, storage, usage, sharing, destruction, archiving, everything comes under processing. The very first part, you collect data or the data collection, the act states that on two bases you can collect and process data. First is consent, and second is other legitimate uses. So the act has used this term, other legitimate uses. But the first and the most important part is consent, that you need to take explicit, freely given, unambiguous consent from a data principal. You need to record the consent. You need to store the consent. It will be the liability of a data fiduciary to prove that this notice was shown. That means this privacy notice was shown to the data principal, and this consent was recorded by data principal on this and this date. So Act clearly mentions that you need to record this. And by any chance, the court may ask you, the board, data protection board may ask you, even the data principal can ask you, show me the proof you took my consent. So consent is a very important topic when we talk about collection of data. Second are the other legitimate uses. There are certain and several legitimate uses which are mentioned in the act, like for example, medical emergencies. Personal data can be processed without a consent. Uh, in the national, for protecting the national security, for the integrity of India, for the sovereignty, these are the exceptions where you don't need to take consent from data principals. You can just process the data. And certain other public interest is also one of them, that state can process personal data without your consent. So if you will see the complete section and complete exceptions from this consent, the other legitimate uses, most of the exceptions are for the government bodies, authorities, and states to process personal data without consent. and that's also acceptable. For example, uh, all of us have the driving licenses, or we have like voter ID cards, or we have Aadhaar cards. When I applied for driving license, I don't remember I gave my freely unambiguous consent to government or not. Now, if the act will ask state or government, go and get consent from every individual who has the driving license, this will not be practical at all.
Yeah.
Nobody can ever think of that all the voter ID holders in India now need to give consent to the states. So yes, there are certain exceptions for the consent, but the most important and the major ground for processing of personal data, digital personal data, and this act is consent. And organizations, especially the startups, need to create mechanisms for recording consent and storing consent. Now, recording consent is 50% and storing consent is next 50%. This is very important. You need to have checkbox and other things. So yeah,
Sure.
that.
And Nakul, if you want to confirm, and this applies for not only customers but vendors, employees, and any data principal or anybody that business is touching upon, or is it only the customers, or what's the definition on that?
So, as Keshav suggested, I mean, he pointed out the distinction between how can we collect the data as, as a business or as an individual if I'm collecting. So, first of all, we need to understand that processing for the purposes of my individual use is not something which is covered under this act. So, for example, if I'm planning a birthday party for my child and I'm collecting a lot of data, which is either in digital or in physical format, that is not something which this act covers in terms of the obligation to be put on me as a data fiduciary. I don't become a data fiduciary in those cases because it is for my domestic and personal use. Now, coming on to the fact that while consent has to be procured, there is another large set which Keshav highlighted, which is called legitimate use, and I believe it is it is also a large part of processing which will happen under legitimate use. And there is an example under the law which says that if you go to a pharmacy to buy medicine, and for the purposes of billing of that medicine you give your phone number and name and email ID, you don't need to give any specific consent for that pharmacy to collect your data. So that is a use case for legitimate use, and I believe you'll find several use cases of legitimate use, which was previously in the previous iteration of the draft called deemed consent requirement. That deemed consent has gone away. There is a legitimate use requirement, which is, I believe, good in terms of the businesses that we are doing, mostly physical businesses, where you go to a shop for the billing, you give your name, phone number, and address that continues to be with the shop owner for a considerable period of time. The important consideration comes here in that while you collect consents, the consent, as Keshav also suggested, that it has several specificities to it. For example, you should have informed, unconditional, unambiguous, clear, and affirmative consent format. Uh, the the practical way to look at it is that while in the previous regime, if you look at privacy policies of almost all websites, it just covers the world. You are collecting every piece of information which you could, even for future use and for transfer to third parties. You could not do that anymore. And while you say that consent has to be specific, if I'm collecting your name, address, and age for that matter, I would need to showcase to the data subject, or the data principal, that why am I collecting the age, what is the purpose of the collection of that data piece called age. uh, while the privacy notices previously had no way of rejecting them, there is a way that you have to right click. It just can't come to you all clicked to say that you have to give all of this. Not happening anymore. uh, so there has to be a positive action. What I meant to say was, there has to be a positive action while you give your consent. It cannot be a pre-ticked option, and you cannot bundle
Sure.
it with terms and conditions. That is what the
Sure.
consent in legitimate use looks like to me.
Sure. No, what I mean, what I also wanted to understand and confirm again is that it's not only customer, but it's also the employees and vendors as well, right? When you are collecting their data, like when you are collecting the employees' data, it also means that they have to also give a consent that, hey, I'm giving this data to you, right?
So
Or
I think under Section 7I, there is an exception from consent procurement for employees. It's a legitimate kind of a use where you offer your data to your employer, which specifically says for the purposes of employment, and to prevent any corporate espionage, and the employer would need your data to process and give you some kind of benefits from an employer employee perspective. You don't need to
sure.
have an express consent requirement there.
Okay. Okay. And what about vendors? Let's say if I have to onboard a vendor for, say, some work, and I want to do the due diligence of that person, right? And I want to collect some personal data of, say,
I
that
believe
person,
that
right?
I
Let's say.
believe that will fall under the consent regime, because you are targeting a vendor individual to collect his information for a particular piece of business. This is not a
Mhm.
legitimate use example per se.
Sure. Keshav, contrasting you, or
No, definitely. And I would like to highlight and add an important point here, because those people who are listening, and there are certain startups who are there and are already in compliance with GDPR. So there is a very big difference for the lawful grounds for the processing of personal data when we talk about GDPR and when we talk about DPDP. In the GDPR, contractual arrangement or a contract for fulfillment of a contract is a lawful ground for the processing of personal data. But lawful ground as such or other legitimate uses, except for the employment contract, it's not mentioned any other contracts. So that section 7 is silent on contractual arrangement as a lawful ground for the processing of personal data. So yes, for vendors, definitely the consent will be required, or your subcontractors, or your maybe any kind of vendor individual. Consent, explicit consent will definitely be required. But maybe in GDPR, those startups who are already in compliance with GDPR will be using contractual arrangements for the processing of personal data and will not be requiring any kind of consent from any vendor. But here's the difference: for vendors, you will be requiring the consent. And this exception of consent is there with employer, but for other sections of this law, yes, those are applicable to employers in a similar way it is applicable to other data principles or the data
sure.
subject.
Great.
Yeah.
So we have common question from Adi and Chinky. What are the exemptions for startups on DPDP? Is there any really, or if there is any, then what's the news? And if there are none, then how do they go about it? So you want to take it up?
Okay, sure, sure. So yes, I saw just start off this stream. There was a question: there are there any exemptions for startup? To be very honest, right now, none in a clear term. But yes, also. But this law is not only okay. In some of the laws or some of the expectations from the startup was like this, that there will be certain exemptions in clear. Okay, all the startups are exempted from this sections. You need not to comply with these sections until unless you are a medium enterprise or you are a large scale enterprise. But that's not the case. However, the act talks about data fiduciary and significant data fiduciary. These are the two terms. There are certain obligations which are mentioned in this act for data fiduciary, and there are extra obligations in this act which are mentioned for significant data fiduciary. Like, for example, appointment of a data protection officer. It's not a legal obligation or a compliance obligation to appoint a data protection officer for any data fiduciary, but it's a legal obligation under this act to appoint a data protection officer for a significant data fiduciary. So we can say yes, there are exceptions to certain organizations or enterprises in the industry, but that clarity will get maybe in some days, because the act states that government will notify significant data fiduciaries in the upcoming days in accordance with this act. Every company, every enterprise, every individual who is processing personal data is a data fiduciary by default, but no one is significant data fiduciary by default. The point needs to be noted here that there is a concept of significant data fiduciary. If the government, central government will tell you, hey, listen, you are significant data fiduciary, only then you are significant data fiduciary, and the extra obligations will only come your way at that time. when you will become a significant data fiduciary. And for example, I mentioned about appointment of data protection officer, and then there is one more obligation which is very pain for startups, and that obligation is appointment of independent data auditor, and then having periodic independent data audits, because that incur a cost. है ना?
Hmm.
If you are having periodic audits every quarter, or maybe once in every 6 months, or maybe once in a year, or you need to appoint an independent data auditor every time, that will incur cost, and that will be a pain point for startups. So luckily and happily, these obligations are not for those companies who are not notified as a significant data fiduciary by the government. You need not
Sure.
to appoint you need not to appoint a data auditor. You need not to have these audits conducted until unless government says specifically that you are a significant data fiduciary. But yes, there are
Sure.
certain obligations, and a very important, most important obligation, like appointment of a consent manager. This
Hmm.
is applicable for everyone,
Hmm.
irrespective of the fact you are a data fiduciary, or you are a significant data fiduciary, or you are anyone. You need to have a consent manager, a full-time or a part-time consent manager, but as a designated position consent manager in your organization for all
Hmm.
companies who are processing personal data. That will also incur cost for startups. So
Sure.
yes.
All right. But on the Nakul, on the something bit more optimistic, do you see any opportunities opening up for startups as well? While Keshav has really given a hard attack to few who have maybe listening, but what do you think? Does it really open up some opportunities for us as well in a startup world?
So no, I am sure that while there is a there is a provision under the act which says that data fiduciaries who are startups will be given some sort of an exemption depending on the area which they cater to, the quantum of the data which they handle. I'm sure there will be some sandboxing which the board will offer to startups. It is not clear in terms of what will those criteria be or conditions be. It is definitely not coming to everyone, every startup who is registered on the DPIIT website. No, not at all. There will have to be certain benchmarks, criterias, and threshold basis which this identification will be made, whether you get exempted from certain obligations of a data fiduciary to not follow the act, which is taking of consent, implementing reasonable securities practices and procedure. It will come with time. Only time will tell. But yes, I do see that happening, which the government has also done in some other spaces. For example, with the rules and regulations on the RBI, the government has tried to create some regulatory sandboxes, and in other sectors also. So yeah, it is bound to come in some form or the other.
Great. No, thanks. Now, when we started when we were starting the conversation, Keshav had a very interesting take on data breach, right? So, can we define in the ambit of the act what is considered as data breach, and what are the liabilities faced by the business overall, and what is basically what happens if somebody hacks in, right? I mean, simple question for any startups to kind of listen in that uh, you have got a consent, you have got everything in place, and somebody hacked your data or somebody leaked your data. What's next? What happens as per the act?
Okay, so yes, now I have a good news for the startup. Okay, so but a bad news for the individuals. To be very honest, to be very clear, you asked about data breach. I guess everyone nowadays knows about data breach. What is the data breach? Unlawful disclosure, unlawful destruction, and a leak of data. We have been hearing this term, I guess, from last 4 5 years daily in the newspapers. Everybody remembers about this Zomato data breach, eBay data breach, I guess back in 2016, and Domino's data breach last year. So every details of your orders, your mobile numbers, latitude, longitude, with credit card details in some cases, was live on open internet by some group of the hackers. The complete Domino's database was there on the public internet, and that was accessible to everyone. Still, it's accessible. So data breach everyone knows. Now, the most important part, the consequence of the data breach. under this law. There are certain obligations which enterprises and the data fiduciaries, processors needs to follow. Is notification about the data breach without undue delay to the Data Protection Board of India. Second, notification about data breach to the data principals without any undue delay. And these are the most two important factors. Then you need to mitigate it, you need to do a root cause analysis, then certain other forensic things you need to do, and then you need to submit this complete report to the Data Protection Board, and then the Data Protection Board will analyze that how this happened, why this happened. And coming to the financial implications or the penalties, the capping is 250 crore rupees for any
Hmm.
organization, any enterprise. Yes, under I guess section 17 there is a small mention that maybe for some cases there can be exception exemptions to some of the companies or some of the group of companies or maybe some startups, but it's not clear as of date. So the act says
Hmm.
that financial implication or the financial penalty can be up to 250 crore rupees. Now
Hmm.
the catch here, who will be the owner of those 250 crore rupees? Who will get
Okay.
those 250 crore rupees? The government of India or we, individuals or data principals or data subjects? The answer is the government of India. They have
Hmm.
used that term, if I can recall, consolidated funds of India, I guess, something like that. That
Hmm.
this amount or this money will go into the bank account of government of India, to be very clear. And there is
Sure.
no right to compensation to any individual. If
Hmm.
your data got breached, okay, perfect, you will get zero. That's reality. But
So I think that's very important, kind of
important.
bad news for eventual customers, right? So, uh, but yeah, I mean, very interesting. Nakul, I have a question for you. We are running out of time, so I have to cut short few questions. But how do you see? There has been some questions and conversations around this, various other acts which are kind of somewhere close, like IT Act 2000, RTI. Does it really impact any way or come in any way with DPDP, or do they have conflicts? What's your take on those kind of other acts? Is there any relation to them, or is there not?
Okay, so uh, you know the current regime, I mean, unless the DPDP Act comes into effective enforcement, uh, we are still under the Section 43A regime of the Information Technology Act, which this act particularly sets out that it will cease to see the light of the day once this act comes into picture. uh, but this does not repeal Section 72A of the IT Act, which is for penalty and for service providers disclosing personal information without consent, breach of contract. Uh, so while we are moving to a different regime, uh, we will still have 72A to rely on for penalties, but everything else goes away. So that is how the IT Act going to be affected. The SPTI rules will no more be there. Uh, on the RTI Act, there is this discussion going on, and this particular act seeks to make some regression in terms of the IT Act, which is, I believe, Section 8(1)(j) or IJ of the RTI Act, which is basically which bars the disclosure of personal data if it has no relationship to public activity or the interest. uh, and therefore, through this amendment, if it comes into picture, the qualification with respect to public activity and interest, if it is removed, the information which relates to public information will be exempted from disclosure to a citizen under the RTI Act. I think that's the blow which everybody is looking at, that you've restricted or rather broadened the exemptions for the government, but restricted the scope for the users to seek information from the government under RTI Act.
Hmm. Okay. Very interesting. I think this is a topic in itself, so I'll not go much deeper. But before I take up the questions, we have a few. Uh, a question to both of you. Can you break down what exactly a startup or anyone collecting personal data? should be doing in the next 3 months to really gearing up to adopt this? And more importantly, without spending a bomb of a lot of money, hiring new resource, what's something that practically a startup or a company who is listening in, or who is some way or other doing business or collecting some personal data, what should be their plan for next 3 months? That's my simple, kind of practical question for both of you.
I think
So
Govind,
Nakul,
I think
maybe
Govind,
you take it.
you need to ask. You need to ask a predecessor question. Is that, while everybody has done their sort of rights and wrongs in the previous regime, do they have to unwind it or not? So we have collected so much of data. What do we do with that? Do we have to procure
Yeah.
fresh consents or not? The answer to that is no. You don't have to procure fresh consents. You have to simply notify what you have collected to your users. And since Keshav is on the other side of the table, being a data fiduciary, I'll let Keshav answer the other one.
Yeah.
No, that's very great, and thanks, Nakul, for highlighting this. This is a very important point, and this might be a very pain job or a heart attack to the data fiduciaries if government would have told you,
Yeah.
now go back and take consent from everyone. This would have been a nightmare to any data fiduciary at any enterprise. But luckily, now government is just saying you notify the individuals about what data you hold and for what purpose you are processing data. That's it. In case they don't object, that means you have the consent now to process the personal information. But explicit consent is not required for the previous data you are holding in your databases. Coming to your question that what needs to be the roadmap for the enterprises and the data fiduciaries or the data processors for next 90 days, 3 months plan. First, when we talk about compliance now, there are lots of policies, procedures, notices, consents, those type or such kind of things attached to it. They need to update their policies, privacy policies, website notice, their cookie policies, which are very important because those information are available in public, and if they need to rectify those things, they need to have the data subject rights mentioned in their website, because that's again a legal requirement under this DPDP Act, that you need to mention about the data subject right. You need to mention about the grievance redressal officer. You need to mention about details of the point of contact with whom data principals can connect to exercise their rights. So one part is this policy procedure. Second thing, from an implementation standpoint, what I'll suggest from my personal experience also, enterprises needs to work on their data inventories, or we call it as record of processing activities. It's a defined term in GDPR Article 30. Yes, I agree. Record of processing activities is not a compliance requirement under DPDP. I agree. But for enterprises to know what amount of data they hold, what data is required for them to be stored, what data needs to be deleted, which data is not at all important for them, what data is there in their system. I can bet 90% of the organizations in the industry don't even know what all data they have in their databases. That's a reality. They don't even know what all data they have. So they need to maintain inventories, and then make a list all data elements what they have in their companies. Then they need to make data flow diagrams, and they need to decide then what data they have in their organization is breaching any principle or obligation of this law. Because this law is very clear on data retention, archival destruction, that you need to delete the data after you receive a withdrawal of consent from an individual, or that data is no longer required. So if tomorrow data protection board come to you and audits you, and they will ask you why you are storing this data, you will have no answer. Then you need to clean up your spaces. You need to delete all the irrelevant data which is no longer required. And then you need to make data flow diagrams, and then that's it for a starting phase for the enterprises. Appointment of consent manager is also required. That also they can be done. But as far as I can, from my personal experience, or I can think that enforcement date of this law will be minimum after 12 to 16 months. Minimum. The government will give at least 12 months time to all the data fiduciaries, to all the data processors to be in compliance with this law. Because GDPR came in 2016. The enforcement date was in 2018. So the European Union gives 2 years time, 24 months time to all the data controllers, data processors to be in compliance with this laws. In the similar way, plus also section 3 of this act is very important. I guess section 113. Huh? The government is saying This act can be enforced in pieces also, can be enforced in one go also. That means there can be a probability the government will say, okay, first 10 sections will be enforced from, say, for example, hypothetical, 1st April 2024. Next 10 sections will be enforced, for example, 1st Jan 2025. This can also be a case. So we need to wait and watch, and
Sure,
that's it.
sure. Nakul, your view, next 3 months, or let's say now, it has given a lot of breather as Parkinson's deadline rule says that everything happens in the end. So I think everybody will be relaxed by 12 months. So, but let's say what's next for the 12 months we should be doing as a startup, right?
See, I would not just restrict itself, I mean, the compliances to just a startup because, while startups in this day and age, in the technology world, may be collecting more data than anybody else, but it applies, there is no distinction in the sort of that, who is collecting what. I mean, if you're collecting data, you might as well do it today. And what I see is that there are simple measures which people can start looking forward to in terms of, as Keshav also suggested, just map your data. At the end of the day, it's a housekeeping exercise. Your house is clean, the board will not come, but your house has to be clean. So, for to identify your house is clean or not, or whether you have collected certain piece of information which you actually don't require, that is the exercise that everybody has to do at this point in time. I believe with with time to come, there will be many agencies which will, third party agencies which will conduct a data audit, data mapping exercises, and would tell you that, this is the data. You are required to keep this data for the purposes of your effective delivery of the services. This is the data which is irrelevant for the delivery of your services, and you might as well delete it or take consent, which also has to be justified in terms of your data processing activity. Uh, apart from that, people would definitely have to work on their technological abilities to collect the consent, because collection of consent, as this act provides, has to be in a very very specific granular format. So, tick boxes, the entire change in the UI UX, people would have to do that. And I believe that that is what will take some time and resources internally, financially, and HR both. That
Sure.
is what I believe, the companies should be cognizable of.
Great. No, thanks for sharing that. Now, before we close, one question from Divya. Hi, I have a doubt regarding the jurisdiction purposes. As we know that GDPR and the Act itself, as both are implemented internally in the territory as well as in cross-border jurisdiction at the same time. So, the question is with regards, is there any conflict? Then who will prevail, GDPR or this Act? Any view on that?
Okay, so I'll take that up.
Yeah, yeah,
If
sure, sure.
Okay,
Go ahead.
so this act clearly states that data principles of India. This we need to see the terms very sharply. That the scope of this act does not cover the term resident or the citizen, because whenever we see any act or whenever we read any act, either we'll find the resident of India or the citizen of India. This act states that it is applicable to the data principles of India, with irrespective of the fact data is getting processed within India or data is getting processed outside of India. If there is an outside company XYZ Inc from US, but that company is targeting Indian data principles, this act DPDP will be applicable. Same with GDPR. Na? GDPR also states they have extraterritorial jurisdiction, that if you will target my European residents, then GDPR will be applicable. Indian companies targeting European residents, GDPR applicable. European companies targeting Indian data principles or Indian data subjects, DPDP is applicable, because both of the governments and both of the laws are protecting their own data principles or data subjects. Whenever there will be question of Indian data subject, this DPDP will come into picture. When there is a question of European data subject, GDPR will come into picture. But one more point GDPR extra has is, if you are an Indian data subject or you are an Indian data principles or a citizen of India who is residing in Europe, then GDPR will also apply to you, to your data. So that's a difference.
Sure. Thanks. Thanks, Keshav, for adding that. So,
So, Govind,
I think, yeah.
just one more thing to add here is that what Section 3B says is, this act applies to processing of personal data outside India if such processing is in connection with goods or services, offering goods or services to data principals within the territory of India. So, you may be a foreigner sitting in India, but if your data is being collected, you need not be an Indian citizen for this act to apply.
Hmm. Okay. Very interesting.
Yes.
I think we're out of time, gentlemen. I wish I could continue this conversation. It's a very, very interesting topic, and but I do believe that we have got a lot of clarity today in terms of how to really look at it, what's to do next, and of course, it's something that we anyways have to uh, you know uh, to kind of evolve with this law as well as we as an organization as well, right? So thank you, Nakul and Kesha, for giving us your time and helping our audience to get a better understanding of the DPDP Act. Now, before you leave, one final of advice to our audience, and also Nakul, thank you for collecting that. You have already posted this on this topic, so my team will also be sharing that link right away. Thank you for that. So, you know, Arctic team can share this link on the LinkedIn Live. People who are
So
listening in, they can.
just putting in a few words, what we have tried to do is we have tried to segregate each in important sector. I mean, just highlight the key data collectors of the entire industry, which is e-commerce, BFSIs, hospitals, employers, and try to identify the set of data, set of obligations and rights which the data principals have against these kind of data fiduciaries in each sector. Uh, it's a small compiled table which can help you to understand your rights and your obligations as a data fiduciary. We are coming up with more such data material specifically targeting businesses in India and across overseas. But yeah, that's the data which we have created so far.
Great. Thanks. Final piece of advice, Nakul and Keshav, before I let you go.
Oh no, I think we're all good. I mean, waiting to have this piece of legislation start acting up, putting down its clause. Uh, I'm sure this is a principle-based legislation, unlike a GDPR, which is more nuanced. But I believe as we in India are the data collectors of the world, we are not somebody whose data is being collected. Indians, people sitting in India, their data is hardly collected across the world. I mean, things will change in future, but as of now, living in the service sector industry, we are the largest data collectors of the world, and therefore compliances to that extent has been reasonably well qualified and determined. There's the concept of adequacy while you transfer data into India is still not there, because there is a negative list which the government will publish, and this is important for people who do a cross-border transfer of data. So while from India and to India, there can be a free flow of data transfer, and there is no data localization, hard-coded obligations which we used to find in other previous iterations of the law. To that extent, I believe it is largely a business-friendly legislation, but time will only tell how difficult or easy it is to implement.
Right. Keshav, any last advice?
Yeah, sure. So, this is in real very, very business friendly legislation. And my advice will be please stop buying data from the market and
Yeah,
collect
absolutely.
only what you require for the purpose. Your purpose should be very clear in your notices and your policies. You need to stick with those purpose. Don't cross the boundaries of the legitimate purposes and the legitimate uses mentioned in your notices and your policies, because then it can be a bad time for you. But until and unless you are working under the ambit of the purposes and your lawful grounds, as far as this law is concerned, you don't need to worry much, honestly. But yes, please don't be in data trading practices or data selling practices or collecting extra data. It's collecting extra data is the biggest crime I can think from this law. So yes, that.
Thanks. Thank you once
And
again, both of you.
one important thing, most important thing, sorry, I forgot. There is no criminal liability in this law. So startups and other companies, enterprises need to be very happy.
And no suo moto action also by the government,
No suo
unlike
moto.
GDPR. I mean, where they can go, after Facebook and everybody, if they have not maintained that data flow, there is no suo moto action which this law talks about as of now.
Mm, mm,
No arrest,
great.
no jail, no police, nothing.
Okay. Good. I hope that still makes this law implementable. But thank you for saying that, and thank you for telling us. At least I'm sure a lot of people who were worried will be more relaxed now. But thank you both of you once again. It was really pleasure hosting you, and thank you for sharing such a detailed, yet very simple discussion on this which topic, which is of course like Keshav says, privacy is a myth, right? So, so thank you again, and I wish you a great week ahead, and thank you. And I'm sure people can follow you and reach out to you for any further questions, and looking forward to have more engaging topic on this. So, thank you again. Thank you, Nakul. Thank you, Keshav.
So much. Thanks, everyone.
Thank you. Thank you once again, audience. Do follow me on my LinkedIn and also our page Arctic Invent, so that you can be informed on the next of startup series. And of course, looking forward to host you in the next session. Thank you. Bye bye.